You see, our main submission attacks in the way the judge came to the conclusion. From the start, we have said his finding at the end of the prosecution case was totally flawed. It is our considered view that defense ought never have been called because the prosecution has not proven the Section 23 offence, which is the corruption offence, the 409, 3 charges, never proved, for the various reasons that we have given. And these reasons are solid. They are not reasons that we picked up from a mere misconstruction of a sentence by a judge. What we said was the judge misconstrued concepts in law, and as a result, he misunderstood what basically amounts to proof. He completely ignored the fact that in criminal law, whenever there is a doubt in terms of how you infer from a set of facts, how you do an inference further, if the inference can be against the accused, but at the same time, there is alternative inferences that you can make. And some of these inferences can be in favor of the accused. The law demands, you have no choice. The law demands that the inference that is most favorable to the accused must be taken by the judge. In our case, we have shown that what the learned judge did was, during the prosecution case, he just went through the prosecution case without detailed examination of its flaws. The serious flaws that we have pointed out, he never examined. Okay? That's fundamentally flawed because the law requires you to do a maximum evaluation. Meaning, every witness of the prosecution, you examine the credibility, the veracity of the testimony, and so on. All right? He didn't do that at all. Now, but when he called for the defense, during the defense, he suddenly became very analytical. Every statement from the defense, he examined them whether or not it can be true, which is a wrong burden that you have placed. During the defense case, all you need to see is, even if you don't believe the defense, if it raises a doubt, you give the benefit of the doubt to the accused. You remember there is a famous saying, it is better to let 10 guilty men free than to hang one innocent one. That's a concept in English law. That's also the concept in this country, because we are based on a common law system. Okay? So that's the main thrust of the main argument. Okay? Now, Harvey has dealt the last 2 days, I think, of why Section 409 offences have not been met, because there are 3 offences. The main one is, how could you say the Prime Minister or the Minister of Finance, because he holds both positions, be an agent of SRC's fund? You see, you are not only supposed to hold the dominion of the fund. You either have the fund in your hand, or you have dominion and control over the fund. Now, Dato' Sri Najib is not even within the company. He's not a signatory. He does not control the fund. We're talking about the fund of SRC. We're not talking about anything else. If you do not control, you do not have the dominion, the principle of agency there is vis-a-vis the fund. Because that's how the trust is created. You see, breach of trust is not called breach of trust for nothing. A trust is imposed on the person who holds the dominion of the fund of the company. He does not hold that position. So fundamentally, it is a serious problem. It is for that reason, I think, when the prosecution suggested to the court that you have to treat him as a shadow director, the judge grabbed that opportunity and said, okay, he's a shadow director. And because he's a shadow director, he has got control over the fund. But in fact, he doesn't, because this is proven. And the other thing that is critical is this goes towards what I've said earlier. During prosecution case, he examined not at a maximum, which he's supposed to do, but during our case, the defense case, he examined in the most minutest way, which he shouldn't do, okay, because that's imposing a lot of burden on us. You remember we said Subo, Datuk Subo, and Faisal, Nick Faisal was supposed to be the person who signed all those instructions to transfer the money, very importantly, the money out of SRC. Where the money goes to and then finally come back to Datuk Sri Najib, or whether he went to two companies, or they did replacement, or they did repayment, that's not so relevant, although it is important for our purposes. Yeah? But for your purposes, to understand the CBT, who caused the money to get out from SRC's account? That's important. The prosecution say it is because of the instruction. Subo signed, Nick Faisal signed. Okay? We have proven conclusively, Subo himself, their own witness said, when I demonstrated his signature being a complete photostat copy, he said, that's not my signature. In all the instructions. You need two signatures, okay? Subo himself said that. All right? Now, Subo, when giving statement to the MACC, have also changed. He gave 5 statements. This is before he comes to court. He gave 5 statements. Out of the 5 statements, 2 statements at least, he said, that's not my signature. Okay? But somehow or other, when they got him from overseas with some promises, Subo, in his witness statement to the court, said, that's my signature. That's before cross-examination. But when he was cross-examined, he completely broke up. Yeah? So I don't know whether some of you attended the trial. And there was a time when he literally was complaining, why are you doing this to me? He literally said that. Okay? But he broke down. The word I want to use is, he broke down in his testimony. He finally recanted. And he said, the MACC never showed it to me the way you are showing it to me. You meaning me. Because I demonstrated to him all his 17 signature. If you put one on top of the other on the transparency, they become one signature. Nobody in the world can sign that. Identical signature. So that, Subo is gone. As far as I'm concerned, you cannot save Subo. No matter how clever a judge wants to be, you cannot save Subo. Now, what did the prosecution do? Did they repair that? No. They accepted it. They did not re-examine Subo. When Subo said, that's not my signature, nobody in the world can sign like that. Subo said it from his own mouth. Subo said nobody in the world can sign identical signatures. 17 times when I showed him. For our purposes, the transfer was 6 times. So he said that is forgery. Okay? The prosecution not only did not repair that, but they, for some reason I don't understand, they demonstrated to Subo Nick Faisal's signature using my technique. And they said, you say your signature is replicated like that? Look at Nick Faisal. Nick Faisal also like that. So what does it mean? Does it save their case? He made it worse. That means the 2 signatories, the only 2 signatories allowed to sign out money from SRC, was shown to be not signing it. It was all forgery. Of course, Nick Faisal didn't give testimony because he's not in the jurisdiction. But Subo alone has damaged it. if nobody can prove who moved the money from SRC, it doesn't matter who is the shadow director or not. Because in order to show that Datuk Sri Najib has got a control about how the money moves out of the company, you have to identify whether the signatories moved the money out or somebody stole the money by forgery. If it is forgery, the person cannot be doing a CBT because he doesn't have custody of the money. You understand? Somebody in the management literally stole the money by a process of forgery and sent it out. Okay? So the question of CBT drops. Okay? Now comes to section 23, which is what they call it, Farhan Reid's position. Farhan Reid today, the biggest point that I think is hit is this. I think the prosecution, before even they started with the case, they have got a nightmare of a problem of drafting a charge. What they have drafted at the moment is this, that you were using your office position in approving, because they mentioned 2 dates. They didn't say about the 2 cabinet meetings. But from the 2 dates, Farhan has said the 2 dates cover the 2 cabinet decisions. Okay? So they say you have used your position, your office rather, in making that decision within the dates that has got a benefit to you. If they had stopped there, that would be section 23. But they have confused themselves by putting in that charge until today that you were in fact expecting a gratification, in this case a bribe, of 42 million. You understand? Okay. You and I know that is a separate offense. Namely, and Farhan was at pain to stress it. If I do you a favor, I say, okay, I tell SRC, Prime Minister, tell SRC, I will get the cabinet to approve the government guarantee. For the 4 billion, there are 2 government guarantee. I will get it to approve, but you give me 42 million, assuming that is the situation. That's straightforward bribery. What nonsense about section 23? So section 23 offense is separate from a 42 million bribery. But they put the whole thing together and convert it into a rasam. You can't even see where is their case. Now, the best part is the judge himself made it even worse. We started off with 42 million. That was his finding in a prima facie. But when he considered the defense, he said, no, that is not all Datuk Sri Najib was benefiting. When he put himself in the conflict of position using his office, he actually opens up the entire horizon of SRC fund. Not only 42, all SRC fund. He was able to put his hand into the till and take as much as he wants. 42 million happens to be a mere coincidence. Okay? So, you notice, that turns it into a complete dalcha. Because we do not know what on earth he's talking about. Yeah. Today we are all very hungry. Okay. Now, so you see the point. He has shifted the goalpost. Not only has shifted the goalpost, if the prosecution shifted the goalpost, I can understand, because they are all out to win. But the judge has shifted the goalpost from a mere 42 million gratification. He now says, no. It's much bigger than that. Now, some of the cases which Farhan has read out, some of you may not catch it. Namely this, very important principle. If a judge has a change of mind somewhere during the case, that change of mind, if it affects a charge, you either amend the charge so that we are notified, this is where you're looking at, yeah? But somehow or other you must alert especially the defense, that this is what I'm thinking. If you have changed in quite a fundamental and in quite a structural way from the prosecution charge to something else, because you moved the goalposts. From 42 million, you said no, the entire fund of SRC was in fact your reason to act in conflict, which is a bigger door that you have opened. All the cases say, if you think about it, you see, a judge is not supposed to have his own thoughts privately when you're doing a criminal case, because the accused is affected. Datuk Sri Najib is affected. Datuk Sri Najib never defended about the entire SRC money being available to him as the judge found, because the judge never told him, I'm thinking like that. In criminal law, you have to give a notice. I want to amend the charge from 42, it is this. Then you read the charge. And then the accused will say, okay, I'm not guilty. Or he may want to plead guilty, up to him, but it's most unlikely here. Then he is notified, okay, this is where you're going. You must do it before I close my defense. Ideally, you must do it at the end of the prosecution's case. When you call for the defense, the judge must say, I find there is a case, but I will need to amend the charge. Why you amend the charge and read it to him? That is a show cause. Even before you get sacked in a normal company, they have to tell you, you did this, and we find that that can be an offense by way of the company rules and regulation. If you do not give us a satisfactory answer, you may face certain disciplinary action from a merely being scolded or to being sacked. That is a simple job, But here, you're going to be sent to the prison. In some cases, you're hanged. A judge cannot have a private thought about a possible offense that I'm going to find this fellow guilty without telling him. There are many cases. In fact, tomorrow I've got another case. Saidin Tambi is another case where the judge changed her mind from one section to the other without telling. She found him guilty only in the grounds of judgment, the final one. Same thing here. This idea about 42 million becoming a larger one, none of the lawyers know. Certainly the accused didn't know. Only the judge knew. Not even the prosecution knew. Because for the first time he expressed that was in the ground of judgment. So where is my right to defend? So you see, these are very fundamental. I see that the judges here are very troubled. I'm not going to say that we're going to win or anything like that. But I see that the judges here are very troubled because these are fundamental criminal justice system. And this is why I was very much I was worked up to see that a judge in the criminal court who's going to preside, and this is no exaggeration, a case of the century, not just for Malaysia, because even the world recognize this is one of the biggest cases you can ever have. You can't send someone who has never done a criminal trial in his entire life. That is always my position, with the greatest of respect to the judge. See, because you must have not only the knowledge alone, maybe you can read, but 3/4 of what we have submitted, what I have submitted, Habib submitted, and Farhan have submitted, 3/4, I can tell you that, you cannot read from the textbook. These are all picked up from very specialized cases, a lot of experience, and what we do is, having experienced all this, we put the principle in order, and then we gather cases from everywhere to support that idea and the principle. So a judge who presides over cases like this must be armed in his soul and his spirit. He must be armed in order to deal with this position as and when it arises. So, you can't treat criminal courts as a cold storage. The worst judges put there, like a punishment. You can't do that. I'm not saying this happened here. You always have to treat the criminal court, and maybe this is the time for me to say, criminal court should be the best of judges with experience. And I've said that. You know about Datuk Harun's case? They brought down who? From the federal court. They brought down Sultan Azlan Shah. That time, Raja Azlan Shah. The best judge you can have in Malaysia. They brought him down the federal court to be a high court judge because the case is serious. The second Datuk Harun's case, they brought another very superior judge called the Lion of the Commonwealth. The legal lion of the Commonwealth, which was Yusufi Abdul Qadir. You remember? You all are still young, but the best judges, okay? Mokhtar Hashim case, who did they bring? Hashim Yop's son, not juniors. And in the case of Datuk Sri Anwar, they got Augustine Paul as the first judge, and then they had another judge. All are experienced judges who have done criminal cases all their life. They also are experienced in civil, but they are mainly involved in criminal cases. And Augustine Paul was a writer, is a writer of many books, and his book on evidence is now the leading book. So that's the sort of judges you have. Okay?